Hey, welcome back, faithful politics listeners and watchers. If you're watching on our YouTube channel, we're glad to have you. And don't forget to like and subscribe. I am your political host, Will Wright, and I'm joined by your faithful host, Pastor Josh Burtram. How's it going, Josh?
Doing well, thanks.
And this week we have with us Rachel Morrison. She's a fellow at the Ethics and Public Policy Center, where she directs EPPC's HHS Accountability Project. She's an attorney. Her legal and policy work focuses on religious liberty, healthcare rights of conscience, the right to life, non-discrimination, and civil rights. So thank you so much for joining us today, Rachel.
It's great to be here.
Yeah, and you know, I'll just jump right into it, and I want to kind of focus our conversation really on two elements that I think are unique to your background, or maybe not unique, but maybe unique to the show in your background, and that's religious liberty and healthcare rights of conscience. And the latter is a term I don't think I've heard very often, healthcare rights of conscience. So I'd love maybe if we can just start there. Like, what the heck is that? What is healthcare rights of conscience?
So there's about 24 federal laws that provide protections for healthcare workers to not perform abortions, sterilizations, or other medical procedures that violate their conscience. And so conscience is broader than religious liberty. So there's certain protections under the First Amendment and other federal laws or state laws for those who have religious objections to participating in something, or protections for their religious exercise. But conscience is a little bit broader than that. And so it includes moral objections and convictions as well. And so these laws are really important because it ensures that folks who want to serve people in the healthcare space and help them are not forced to do something that violates their religious beliefs or moral convictions. And if there is a situation where folks are forced to do that, they're going to end up leaving the healthcare profession. And so these are really important. And the protections usually center around things like beginning of life, like abortion, end of life, euthanasia, assisted suicide, things like that. And then also other things like contraception or sterilization, or things that certain faith groups have objections to, or maybe individuals have convictions about those important aspects of life.
That's fascinating. So I'm wondering what the Loper-Bright decision was. We've kind of talked about that in our correspondence on email, and I'm just wondering, what is this decision? Why is it important? I guess it's the Loper-Bright Enterprises versus Raimondo. This is like the first time I'm hearing about this, which maybe doesn't surprise anyone here listening or on this call, i.e. Will. But I'm just wondering, what is this, and why does it matter? And does it really involve the National Marine Fisheries Service? And what does that have to do with me?
So this is an administrative law case. And so the case itself didn't have any religious claims or religious plaintiffs in the case. But the case was about the standard of review for federal agency regulations. And a lot of federal agency regulations do have impacts on religious liberty for religious groups, for churches, for people of faith. And so this decision does have an impact, even if the decision itself didn't touch on any of the religious liberty issues. So you probably want me to explain a little bit more about what this decision is. So I think it's important to take a step back and think about, like, what are federal agencies and what are they doing and how could that impact religious liberty? So Congress passes a law. You probably remember the Schoolhouse Rock song, "I'm Just a Bill" on Capitol Hill. You know, the bill goes through both houses of Congress. It goes to the president signs the bill becomes law. But what that song doesn't tell you is how a lot of the rulemaking and the regulations that affect people's daily lives, their businesses and the like, actually come to be. So Congress will pass a law and it'll direct a federal agency, and these are unelected government officials in these agencies, to issue rules and regulations implementing the law. And sometimes these are very just generic delegations of power that have been given to the agencies. And so the agencies get into all the nitty-gritty. And over the last so many decades, we've seen an increase of the federal agencies regulating more and more aspects of every area of public life. And the more they do that, the more potential there are for conflicts for religious liberty, the more diverse America becomes religiously and different groups of people, the more the greater likelihood there is that there's going to be certain groups whose considerations are not actually presented or considered in the same kind of way or reflected in these final regulations. And so that's where the potential comes in. So what happens when there is this conflict, whether some plaintiffs are being affected negatively by these regulations? They go to court and they'll sue and say, these regulations are unlawful, they shouldn't affect me, I have these protections. And so there's this conflict between this conflict over these regulations. And so a court has to decide, are these regulations lawful or are they not? And so this is where the Loper-Bright decision comes in, because under a case in the 1980s called Chevron, the court said that if the text of the law that Congress passed was ambiguous, if there was multiple plausible interpretations that of how it could be interpreted by the agency, we're going to defer to what the agency said as long as their interpretation is reasonable. And reasonable is a pretty low bar. It doesn't take a lot to be reasonable. And so this put a thumb on the scale in favor of these federal agencies. Again, these are unelected government officials. They're not accountable directly to the people. And so when a plaintiff would go sue over these laws that are affecting them, the government would have a huge thumb on the scale in their favor. And so the Loper-Bright case was about whether that's the appropriate standard, whether the government should be given this deference against these individuals who are trying to claim that the laws are unlawful, the regulations are unlawful. And so this case said that, no, that's not actually the proper standard. It's up to Congress to pass laws that are clear. The agencies are supposed to implement them. And then if there's a dispute, the court comes in and decides whether there is, what is the best reading of the law. So it no longer puts that thumb on the scale in favor of the government agencies. Even if their interpretation was not the best interpretation, as long as it was reasonable, then they would win. And so this really, I think, brings the power back to the people. It brings the power back to Congress to write rules or to write the laws that the agencies are going to implement in the regulations more clearly and directly, so that the agencies can't go rogue or expansive interpretations that Congress would never pass, that the people that are accountable directly to the people, the members of Congress, that a lot of these issues is something like they wouldn't pass because they wouldn't get reelected if they did something, right? And so it's kind of this deferral of power to the agencies. And so that's why it's really important. And so especially for religious plaintiffs, that when there are those conflicts with those regulations, they're able to have a fair shot in court, especially if they have the better interpretation of the law. And so this Supreme Court case was really important in returning the balance of power and kind of the separation of powers, so that the federal executive doesn't just have carte blanche power to do whatever they want, as long as it's somewhat related to something Congress said at some point, even if it tramples on the rights of religious folks and others.
Thank you for that. That's a really good explanation of that particular ruling and kind of its implications. But I want to see if I understand it correctly, maybe in terms that are very familiar to me. So as our listeners know, podcasting is not my day job. And what I do on the side is I work with people with disabilities, specifically, looking out for their safety and well-being. So with the overturning of the Chevron deference, I've often wondered how that applies, say, like in the OSHA context. So there's a bunch of laws, safety rules that are promulgated, to kind of help protect the workforce. Um, and if there is a dispute with, say, the meaning of a particular OSHA standard, say, like if you were to take like Title 29, which is labor, CFR, Codified Regulations, like 1904, which covers like record keeping. And there's a dispute about whether, say, an accident is a recordable or not. That dispute will eventually make its way kind of up the chain to the Occupational Safety and Health Review Commission panel of folks, and that will kind of decide whether or not, your complaint is valid. Now, ostensibly, you would think that the people that make up this committee, this commission, are all safety experts, people that kind of understand the regulations and whatnot. I don't know that for a fact, but if my assumptions are correct, like, wouldn't you want those people to be the ones that interpret the regulations, given their proximity to the folks that promulgate them?
So I'm not an expert in OSHA stuff, so I can't speak to any of those specific nuances. I think kind of
Sure.
Administrative review is kind of another nuance, and whether that's an appropriate delegation of an executive agency to be having judicial type powers of review and things like that. I think there's arguments for why it's efficient in some ways. But when it gets to a court, I think this is something a lot of people say, and why they supported Chevron, is this idea that the folks at the agency are experts, and we need to defer to the experts, and they know more. But there's nothing that requires the agencies to come up with the best reading of the law, the best like technical expert reading. And I would just push back. Maybe in certain contexts, some people are experts in certain types of things, but the idea that someone who's worked for the federal government for their whole life and, dedicated career public servant, and I don't want to denigrate that at all. But the idea that they understand how business works when they've never run a business or worked in a business, or it is, I think, pretty laughable to a lot of people that work in these businesses. And so folks that don't have the real world experiences, there's so many considerations that goes into these, and so many different people effects, and so many different interests. And so it's the people that are best positioned to say how something's going to affect them are the people that are going to be affected themselves. And so I think that it's like, we'd like to think that these people are experts, but this, having worked in an agency, I think there's certain level of expertise of just being familiar with how things work and the regulations, but it doesn't mean that they're experts on all the nuances and how it'll affect things in the real world. And there's nothing to guarantee that the decisions that the regulations the agency makes on the back end are actually based on that expertise, like, even assuming they have an expertise versus other considerations. Eugene Scalia, who was the former secretary for the Department of Labor, wrote an op-ed in the lead up to this case in it's probably like Wall Street Journal or one of the other major newspapers. And he talked about how, like, he had this idea going in that, like, we're going to have regulations or make decisions on, like, this is the best reading of the law. This is what the experts say, this, that, the other. And then it was just recognition that a lot of these are just political decisions at the end of the day. And there's just so much going on. And it's, what are the political priorities of whatever the administration is, and what are we trying to achieve? And is there a way we can achieve it, whether that's the best way or not? And so that's why it's important for courts to be able to review things, especially when the agencies go too far. And so I think, we'd like to think that it's experts and people that know things, but a lot of times it's not, which I don't know. Once you see how the sausage is made, you sometimes you get a little jaded with some of the stuff.
Yeah.
And,
But what I wanted to ask you was, kind of in the context of, the Loper-Bright decision, religious liberties. I guess number one, if you can maybe talk about instances where, the Loper-Bright decision has helped or even hindered religious liberty in some regards, and then secondly, if it's applicable, you alluded to sort of the lack of experts, on sort of like these administrative committees and whatnot. Well, like in religious liberty cases, like who would be the expert? Like, would you call in like a theologian or something like that?
Well, the experts in those cases would be more folks who are expert on religious liberty law, right? And how the protections for free exercise under the law what the extent those are. And that's what some of the problems are with some of these regulations is they impinge on folks' religious beliefs by requiring them to do something that violates their religious beliefs, or puts a string on participation in a federal program by not being able to live out their faith, or hire folks that agree with their religion for their religious organization, or run their business the way, or nonprofit in the way that aligns with their religious mission. And so the agencies will be like, of course we'll respect your religious rights, and you can ask us for an accommodation or an exemption, but like these are the folks that are trying to push the policy that there's the conflict with, and the idea that they're going to be unbiased like a judge is supposed to be, or that they actually are experts in religious liberty law and how all of the nuances and the case law and all of that applies, I think is not very promising. And so that's why it's important for people of faith and religious organizations to be able to go to federal court and have the judges, and the judges are going to hear the legal arguments from the attorneys who are experts in the religious liberty law and the application, and decide what is the best interpretation, or if there's a factual issue, it can go to a jury of peers to decide those issues. And so that's a better venue for protection of those rights than just trying to hope that some folks in the agency are actually experts and will respect the rights to the degree that the law requires.
So how do you see this impacting the future of religious liberty and religious freedom cases? Like, what do you think the implications of this decision are going to be as people are coming into conflict with some of the laws, or in the next presidential, cabinet, whoever that is, I'm sure there's going to be all sorts of changes that are made and things that are done. And how is it going to affect us in the next 4 years, 8 years? What do you anticipate?
I think it's important to remember that this is just the standard of review. This doesn't mean that the religious folks will always win every time they bring a claim against a regulation for a federal government, right? But what it does, it puts them on an even playing field. It takes away that thumb on the scale in favor of the government, and so whoever has the best legal arguments is ideally going to be winning in court. And the judge, it takes away kind of the hamstringing of the judge to just be like, well, I'm not sure what it means. The agency seems to be reasonable. I'm not really sure it's the best reading. The other folks seem to have a better reading, but we still have to defer to the agency and the government. And so you're not in that situation anymore, right? And so the judge is going to come in, they're going to hear what the government has to say, they're going to hear what the religious folks have to say, and they're going to figure out what is the best reading of the law that Congress passed, the representatives that are accountable to the people, and how that applies. And so it gives them a fair shot when there are those conflicts and they believe there has been a violation of law, a violation of their rights. So it gives them that chance to actually win, to win in ways that it was much more difficult before, even if they had the better interpretation of the law.
When you think about religious liberty, I think most Americans would probably point to COVID as being the most pronounced event where they saw that in conflict, where churches were being asked to have virtual services or not meet, or whatever the case may be. And I me personally, just as a person that at the time had an immunocompromised child, like, we stopped going to church because we just want to protect our kid. But at the same time, we were also somewhat dismayed, and maybe this is just a liberal in me talking, that these churches, would stay open and would be spreading it and so on and so forth. Can you talk to us a little bit about what you were seeing, and maybe like what's the right way to kind of look at this. You got like a public health perspective, that you want to make sure you're protecting folks, but then you also want to respect and acknowledge, kind of this separation, if you will, of church and state.
Yeah, so I think it's important, like we have a First Amendment that protects the free exercise of religion, and folks might have different opinions on what's an emergency, when can government come in, but like there are those protections. And what we saw, and I think this was like one of the biggest issues, is casinos could be open, but a church couldn't, right? And so there's these varying standards that were not applied across the board, and religious freedom in a lot of cases was getting the short end of the stick, while these comparable, maybe to a certain degree, of, the number of people or the precautions or safety measures that could be implemented, like these secular organizations were allowed to do things, but the religious groups weren't. And so it's important that religion be treated equally in those regards. And so that was a big concern, was kind of the downgrading of religion, because folks thought that wasn't important. And again, no one was forcing anyone to go to church. If you have health concerns or you didn't think it was the appropriate decision for you, that you didn't have to go, right? And so allowing folks to be able to make those decisions, but the government coming in and saying, like, church is not good enough, but like these businesses or the movie industry or casinos or, things like those are okay, or those are essential, but church isn't. And that's an inappropriate decision for the church to make there. And so I think you're exactly right that COVID, we saw a big conflict and infringement on I think just individual rights, and then also religious liberty at the same time. And then in another context I was involved with was when there was the vaccine mandates, and a lot of employees had objections to that, and a number of them had objections based on religious reasons. And under federal law, Title VII, which prohibits discrimination in employment on the basis of religion and race, color, national origin, sex, it mandates that employers are supposed to provide their employees reasonable accommodations for their religious observances, beliefs, and practices, unless it poses an undue hardship on the employer. And so they're entitled to accommodations unless it poses that undue hardship. And so what we saw is a lot of employers just assuming that their employees were disingenuous, trying to come up with explanations like, well, the Pope said it was okay to get vaccinated, and you say you're a Catholic, so therefore your theological beliefs are not accurate, and like you can't actually hold that religious belief. And so whether or not there was a reasonable accommodation that could have been provided, whether or not there was an undue hardship to provide an accommodation, a lot of employers discriminated against the employees, like in the process, by not giving them due consideration, by denigrating their religious beliefs, by targeting them, by just assuming that they knew better about what their religious beliefs were than they did. And like, this is an individual, it's like your individual religious beliefs, right? It's not what is the best theological interpretation according to the church or according to your pastor, right? And so the law protects the individual's religious beliefs. And so I think there was a lot of infringement, just either out of fear or confusion, or there's just like a lot going on by a lot of employers in that context that was really unfortunate. And I think kind of on the other side, individuals who didn't want to be vaccinated, and this was maybe the one way out that they thought they were trying to claim a religious objection when they might not have actually had a religious objection. And so it's important that religion's not just used by folks as a way to get whatever you want. And the law doesn't actually, it's not, if you claim religion, you win, right? There's often these balancing of like, is there a reasonable accommodation? Does it pose an undue hardship, right? But I think that was unfortunate because some were falsely claiming religion, but then people were assuming that everyone was, even when a lot of folks weren't. And I talked with a number of these individuals who were basically distraught about, like, do I violate my religious beliefs to keep my job and feed my family, or do I lose my job? Like, what do I do? And again, there's kind of like a whole process they'd have to go through, and no guarantee of what the outcome's going to be. And so I do agree that the COVID kind of era, and a lot of the government mandates coming down did have a lot of impact on religious freedom. And it was something I think that affected everyone in the country, right? And so it was something that was more widespread, where a lot of these regulations, when we're talking about different federal agencies or something like the contraceptive mandate, right? So only those faith groups that have businesses that object to contraception in general or certain forms of contraception, like only those groups, which is a much smaller subset of people, are affected. Whereas COVID, it affected everyone. And so I think it opened a lot of people's eyes to the importance of protections in the law for religious liberty, and then also just kind of the interplay between government regulations and religious liberty as well.
Yeah. How do you like, I don't know, sort through like genuine claims, like religious accommodation claims, and ones that are just sort of, created out of whole cloth, if you will? Because I know like during that whole period, I mean, you've got folks that are like, hey, yeah, I go to the Church of the Flying Spaghetti Monster, which is a real church,
well,
church.
That's in the court does not buy that one.
Okay.
Yeah. So I mean, and I think that's definitely a legitimate concern and something people are saying. And so like when it comes to courts deciding these issues, they can usually suss out those who are just claiming things pretextually. They don't actually have a religious belief. There was a famous case out of the 10th Circuit. There were some drug smugglers, and they said that they were part of the Church of the Cognizance, and this was part of their religious beliefs. And the court's like, yeah, no, like you don't like, no, that's you're just trying to use religion as a pretext to do what you want, to violate the law. And so like when it comes to the courts deciding these issues, there's usually not it's usually not that. And when it comes to like employers deciding it, generally it's a matter of credibility, right? Like, is the person telling the truth or are they lying? And if you don't have any evidence that there's like, this is just pretextual, or that the person is being dishonest, you're like usually it's assumed that the person is being sincere, right? That they're not lying. And so I think a lot of people just jump to that. You're just making this up without any other evidence, or, like, this is your employee who you've known, who's been trustworthy, but now you're saying that they're lying about this, and that's inappropriate, right? If you had a situation where someone was asking for, I don't know, COVID might not be a good example, but say someone was asking me like, oh, can I have Saturday off for this concert I want to go to? And it's like, no, we really need you to work on Saturday. And then they come back and they're like, so there's this religious service on Saturday that I want to work at, right? You know what I mean? And so you're like, right. So the religious service, like also the concert, and so I think sometimes they're like there's the evidence of, and just, and that's may or may not be like sufficient to determine, but it would allow an employer to inquire more and get some more information to kind of figure out what is your real reasoning. But like when an employee is attesting, like, my religious beliefs are X, like we don't want the employer to come in and be like, no, your religious beliefs are not X, or like, I know better what your religious beliefs should be, or like, I read this article that said X, Y, or Z, and let me try to figure out any other instance where you've acted inconsistently with your religious beliefs, or right. And so I think it's like, as a society, like it's just kind of a credibility determination, and that's something the courts are easily able to suss out in most cases when there are those, the Church of the Flying Spaghetti Monster and Church of the Cognizance, and I like those kinds of claims where folks are clearly just trying to use religion to get by with things. But like the individual person, if there's no reason to think that they're being dishonest in the situation, and they're a trustworthy employee, like employers should just assume that their religious beliefs are actually sincere. And most claims, like, sincerity is usually assumed in almost every case. COVID was kind of different, where everyone's like, oh no, we don't trust people anymore. But it's usually claims will fail for the accommodations if there's not a reasonable accommodation we can provide, or it's an undue hardship on the employer. And so that's where most claims and like most of the legal disputes end up in court on those cases.
So when we're thinking about the next several years, right, that we have. I mean, hopefully, we have a lot more than that. But I'm saying, like, in the
Before
next,
Jesus returns, or,
4 to 8,
what?
Yeah,
yeah,
yeah. What are you
there are
talking about?
many, many
You don't
things.
want
We'll
Jesus
just
to
leave
return,
that.
or no?
Let's just leave that amorphous date out in the future of whatever it is. But what do you imagine are going to be the biggest religious liberty cases, the things showing up? Like, what in the laws right now are going to drive these religious liberty complaints, accommodations? Like, where's the crux of this, or the several cruces? I don't know what would you even say, the plural of that, but where are the several points of controversy that people are going to be testing, do you think, in the next 10, 15 years?
Yeah, so the Biden-Harris administration has done a number of regulations that have posed a lot of conflicts for religious liberty. And mostly this is like culture war type issues, right? So abortion. So the administration is pushing abortion policies, even in places that are contrary to law. Like the law says you can't provide abortion benefits, and they're like, "Nah, we're going to provide it anyways." You're like, we don't really think the law says what it means, and so there's a lot of conflicts for like federal employees that are now having to provide abortion benefits. Well, what about those who have objections, and like what are their protections? And so kind of the more abortion is being pushed in federal programs or various things, there's going to be those conflicts. And then also on the LGBT front, the administration's been very pro LGBTQI plus, I believe is the latest acronym that they're using, and pushing these policies in every aspect of federal law. And a lot of this has come from the Supreme Court decision in Bostock, which said that sex discrimination under Title VII means that you can't make hiring or firing decisions based on sexual orientation or transgender status. And so the Biden-Harris administration said that basically any law that prohibits sex discrimination now prohibits discrimination based on sexual orientation or gender identity. You probably are familiar with the Title IX case in the school, or the regulations in the school context. This is being pushed in healthcare. And what does it mean to not discriminate? This means that you have to use pronouns that someone would like you to use. This means that you have to allow males who identify as females into sex-specific spaces. This means in the healthcare context that insurance has to cover the gender transition interventions, including for children. It means doctors have to perform these interventions. If you perform a mastectomy for a cancer patient, you also have to perform a mastectomy for a girl who believes she's a boy and remove her breasts. And so like this is where a lot of the crux of the conflicts are coming from under the current administration. If Harris wins the presidency, I suspect we're going to see more and more of this. She seems to be completely in line. Abortion seems to be a big priority for her in her campaign. She recently said that she thought there should be no religious exemptions to abortion, that doctors should be forced to perform abortion regardless of their religious beliefs. And I think that's really concerning, and also is reflective of, I think, a broader trend in America. As folks become less religious, they don't have the same kind of appreciation for the role religion plays, and kind of those deep convictions of faith that people have, and view it more as special rules. And why do they get something special? And we don't, religions, like we just don't respect religion and don't think that they should, have a license to discriminate or be able to do things that we disagree with. And so I think there's kind of been a broader trend, especially in the healthcare rights of conscience area, that folks in the medical profession like need to do. If the patient wants it, then the doctor should have to provide it, even if there is that conflict. And the healthcare provider probably doesn't actually think that it is good for the patient, right? But then also is something that they can't do in good conscience. And so I think we're going to see more and more of that, especially as just the respect for religion and faith, and the number of people that are religious in America declines. And so I think that'll happen. That'll probably be a trend we see regardless of who wins the presidency.
What about the Pregnant Workers Fairness Act? I know that it's something that you're pretty familiar with, and I think it's sort of tied to what you're just talking about. So maybe you can just start kind of unpack what is the Pregnant Workers Fairness Act, and then how does that sort of relate to religious liberty?
Yes, so the Pregnant Workers Fairness Act filled a gap in employment law. And so Title VII was amended by the Pregnancy Discrimination Act to prohibit discrimination based on pregnancy, childbirth, or related medical conditions. But there was no affirmative obligation to provide accommodations for a woman who was pregnant in the workplace. And so just basic discrimination law doesn't have that affirmative duty to go above and beyond besides like the equal treatment of all the employees. So if a woman needed to sit down more or take extra bathroom breaks or maybe come to work a little bit later or just various things as she's going through just kind of the various physical aspects of pregnancy, there was no requirement unless the employer provided those accommodations to other folks in the workplace. There was no requirement to provide it to a pregnant woman. And so the Pregnant Workers Fairness Act required that affirmative duty to provide accommodations. And so we talked about the accommodations in the religion context. And so there's that affirmative duty to provide accommodations in the, you might be familiar, the Americans with Disabilities Act, right? There's the affirmative duty to provide accommodations for those disabilities. And so this added pregnancy is not considered a disability, and most pregnancy-related conditions are not disabilities, though some might qualify, but many or most do not. And so there was this gap in employment law. So it provided reasonable accommodations for the known limitations related to pregnancy, childbirth, or related medical conditions, unless it posed an undue hardship on the employer. So the same standard with religion and with the Americans with Disabilities Act for the accommodation. So that's pretty standard employment law. And this was something that everyone supported, right? Like, we want pregnant women in the workplace to be able to work, to have healthy pregnancies. It was supported by Republicans and Democrats. It was supported by women's groups and like Planned Parenthood. It was supported by the U.S. Conference of Catholic Bishops, right? The whole spectrum. I had raised some concerns, and I think a few others had, that we believed that the EOC was going to take this law and say that it mandated abortion accommodations because of what the EOC has said in the past on certain things, the way the EOC.
Rachel?
Yes.
Real fast, can you just explain or talk about, or people that aren't familiar?
Sorry. The EOC. So I used to work at the EOC. So it's the Equal Employment Opportunity Commission. And so it's the federal agency tasked with preventing and remedying employment discrimination. So they're the agency you go to if you were fired because of your race or you didn't get an accommodation for your disability. And so kind of like what you were saying with OSHA, there's kind of an administrative agency review, and then you can go to federal court and sue if there's that violation. And so the EOC often will push the law where it wants it to go and not just take the law as Congress written it. And we've seen this in other situations. And the EOC has also been very, very, what's a good word? Just not very favorable to religious liberty, especially religious liberty organizations. They often take a very employee-centric approach. And so when a religious organization wants to run their organization in accord with their faith, and someone claims employment discrimination, the EOC often does not want to give the religious organization kind of their due protections that the law provides for them to run their organizations the way that is in accord with their faith. And so there was concerns that if the EOC interprets this very broadly to cover abortion or other things, that there could be these conflicts for religious organizations who don't want to provide accommodations for abortion. And so after the law was passed, it was celebrated, but then the EOC came out with its regulations, and it interpreted pregnancy, childbirth, or related medical conditions to cover abortion, use of contraception, fertility treatments, sterilization, basically anything reproductive related. And so you have a situation where an employer, according to the EOC, could violate the Pregnant Workers Fairness Act by not providing an accommodation for an employee who is not pregnant, was not pregnant, and might never become pregnant, which is pretty crazy because the law itself was supposed to protect pregnant women and help ensure healthy pregnancies and healthy babies. And so this obviously poses a lot of conflicts for religious employers who have objections to abortion, those who have objections to contraception, fertility treatments, especially those that abortion is often tied with destruction of embryos and things like that, and a lot of the fertility type treatments, sterilization. Different groups have views on sterilization. And also, it's interesting because the Pregnant Workers Fairness Act protects pregnancy, childbirth, or related medical conditions. But now the EOC is saying it's covering medical interventions, like not just a condition, but like an intervention itself. And so this was a major concern. The USCCB issued a report at the U.S. Conference of Catholic Bishops, issued a report at the beginning of this year on the top 5 threats to religious liberty, and the Pregnant Workers Fairness Act regulations were one of them. And they were very instrumental in supporting this law. And they're like, look, that's not what the law says. That's not what it was passed. Democrat and Republican co-sponsors on the Senate floor said that the EOC could not mandate abortion accommodations. Concerns had been raised by a couple senators. And so this idea that it mandates and the agency can just say that it does when this is something that would not pass Congress, it would not have received bipartisan support, right? But the agency can just interpret it the way it wants. And so I think this is why the Loper-Bright decision is important, because an agency could, or a judge could say, well, you don't really say what related medical conditions are. Maybe, I guess it could be reasonable. Maybe this is a good interpretation, or maybe it's not the best interpretation, but we have to defer to the agency because the agency is the expert, right? And so like, this is like, no, what is the best interpretation of pregnancy, childbirth, or related medical conditions? Does this cover abortion? And so the USCCB and the Catholic University of America sued EOC over this rule. They won a preliminary injunction, and so they're still in litigation. Some states have also sued over this regulation that have pro-life laws. And they're like, look, we don't want to accommodate, like, do we have to accommodate abortions that are unlawful under state law? Like, this is not something that we want to have to do. This violates our policy. This is not the law that was passed. And so these cases are in litigation. And the fact that the agency doesn't get kind of a free pass to have creative interpretations as long as it's reasonable, I think is a good thing, in that it reins in kind of the excess of these agencies of going beyond what Congress said, and doing things that Congress would never do and probably could never do, like mandate that America's employers accommodate abortion across the country, which is pretty crazy, because it's probably one of the most controversial topics in America. And so, this idea that this bipartisan law just, snuck that in there without saying abortion once, is pretty crazy, but it's something that's being litigated. And because of the Loper-Bright decision, like, there's a fair chance for the plaintiffs and USCCB and the states to be able to have their arguments heard on the same playing field as the EOC and not just have to defer to the agencies. So I think that's a good thing.
Yeah, that makes sense. I want to make sure I understand this. So Congress passes a law. And I know we've been talking about it, but I want to say it out loud so I can make sure I got my head wrapped around this. Congress passes a law. This law goes to the executive branch to execute this law, right, federally, which they're not state laws, they're federal laws. And so the execution of this then gets passed down to agencies. And then agencies have to interpret that law. And as long as their interpretation falls within somewhere reasonable, which I'm not hearing a lot of, understanding of what, or limits on what reasonable really even means. And then once that happens, then they have essentially kind of sweeping authority to, implement these policies nationwide and wherever I guess their jurisdiction falls in whatever agency it is. And I guess, am I getting that right?
So
I mean, is that
that's the standard under Chevron before the Loper-Bright decision, was if there was some
now?
ambiguity under what the law meant, the scope of it, the agency could do something that was considered reasonable, and that was wide latitude. And so it gave the agencies power there. So the Loper-Bright decision says, no, the agent, like, we don't just defer to the agencies. Like, both parties have to, will argue what the best reading is, and the court's going to decide what the best reading of the law is, and then whoever has the best reading, that party will win in court. And so,
but it's still up to being challenged first. Is that, like, does their interpretation need to be challenged before anything? Like, how is that interpretation even? How do they even come to that interpretation? Like, I get,
like, the agencies
guess,
come up. So the agencies
yeah,
will draft regulations. The regulations will be presented to the public. There'll be a public comment period where individuals can submit feedback, supporting it, opposing it, asking for questions, providing other considerations. And then the agency will consider all those comments. They don't necessarily have to agree with them, but they have to be responsive. And then the agency is going to finalize it. And so, so that's kind of like the background process of how the agency will get to where they are. But there's, like I said, it's not just kind of, there's not necessarily just legal experts saying, here's the best reading of the law, and that's what they defer to, or business experts saying, like, well, this is going to have a negative impact on employers. But right, it's like the agency has certain priorities. There's the politics involved of whatever the priorities are of the administration. And so they'll say, no, we think this is the best reading of the statute. And so I think this gets down to the litigation before. There was a lot of argument over whether a law was ambiguous, because if you could say a law was ambiguous, then the agency would almost automatically win. And so the agencies would claim, oh, this is ambiguous. Oh, look, we have this interpretation. They have that interpretation. Therefore, it's ambiguous, right? Because we don't agree. And then if it was ambiguous, then the agency would get that deference and they would win almost every single time. Now the agencies, there's not really that incentive to argue that something's ambiguous. Now we've seen, and we see all this in the PWFA cases, is that the EOC is arguing, no, Congress mandated that we require abortion accommodations. This is a plain reading of the text. And so they're trying to argue that the text itself requires their interpretation, not that it's ambiguous and they can interpret it how they want, but that it's actually like the best reading or the required reading of the text itself. And so the arguments in court have shifted, and kind of how the agency is going to respond, I think, is going to shift. Kind of how courts deal with that, I think it's way too early to see, right? Like, it'll probably have to come back in 5 years and see how it's played out. But I think it's going to shift the agencies away from trying to claim the ambiguity, which gave them that almost automatic win and deference, to no, the text itself actually requires this. And this is what we see at the PWFA litigation. They said that, like, they had to require accommodations for pregnancy, childbirth, or related medical conditions as requiring abortion accommodations, like that Congress mandated it. And so, like, that's more the argument space that we're in. I mean, I think that's pretty crazy that a law that doesn't mention abortion, and the most controversial thing that that's the obvious reading of it, and that's the best reading of it. But the courts are deciding that right now.
What's, in this hyper polarized political environment we're in, it's fairly easy for both political parties to assume, there's this diabolical plan to write the law in such a way that advocacy groups can interpret it and then tie it back to it being a congressional kind of thing, and kind of claim victory. And I'd love to kind of just get your sense of, was this just clever posturing, maneuvering by Democrats, to introduce this kind of stuff under the radar, with the understanding that there's going to be an interpretation of this law that will benefit their political sort of ideology or whatnot, or is this just it's just a well-written law and really smart lawyers figured out how to sort of make something out of nothing?
So I think it was entirely foreseeable that the EOC would try to do that. That's a different question of whether the law itself gives EOC room to do it. And so the EOC has tried to claim that the Pregnancy Discrimination Act prohibits discrimination based on abortion. And so it was completely foreseeable. I warned people that the EOC was going to try to do this. But that's a different question than, does the text of the law itself actually allow the EOC to do this? And I would say no to that question. I think there are ways that the law could have been written better. I think having an explicit abortion exemption is like the only sure way to ensure that like an agency cannot attempt to try to do it. I don't know, maybe even then they might attempt to try to do that. But like that, kind of the belt and suspenders approach. And right, like if you're really concerned about something, don't just give any room, right? Like, you have the belt of saying like it only, pregnancy, childbirth related medical conditions, right? Like that's not abortion. But the suspenders is like, just to be clear, this does not cover abortion. And this is something that the Democrats refused to include in the law, which I think tells you everything you need to know, is that it was kind of like a nudge, nudge, wink, wink. We're just going to pretend like it doesn't cover abortion. We're going to stand up on the floor and say it doesn't cover abortion. And then on the back end, after the law passes, we're like, oh, it's so great. We think it totally covers abortion. The Democrat Senate co-sponsor did just that, stood on the floor and said it couldn't cover abortion, refused to, introduce language that would say so explicitly. And then on the back end, after EOC issued regulations, was like, we think this is great and like we support this. And so I think it's just really disingenuous. And it goes to show that the law would not have actually passed if it did cover abortion, and folks were honest about like that's what they were trying to do. But again, I think the text of the law itself is pretty clear that it does not, and that's how the court should come down. But it was entirely foreseeable and predictable that that's what folks were going to try to do, especially in the post-Dobbs environment where the administration was trying to push abortion kind of throughout the various federal agencies in any and every way, and disregarding the limits that were existing in law and trying to find loopholes and in various ways to try to support abortion to the kind of as far as they think they could go.
I have so many questions. I know Will does too. And, we're getting to the end of like the time that we normally allot. And so I'm going to shift to this. What legal cases are you currently paying attention to that you think others should pay attention to that are going to have pretty significant or potentially significant religious liberty implications and consequences?
So I work a lot on government regulations, so it'll probably come as no surprise. I follow a lot of the litigation that has been on these regulations, like the Title IX cases, the PWFA cases, that like the healthcare ones that are trying to impose the transgender mandate on healthcare, things like that. But the case I think that's really important that the Supreme Court is hearing this term is United States versus Scrimeti. And so this is a challenge to Tennessee's law that protects children from the gender transition medical interventions that are harmful, irreversible. And so until they're adults, they can't receive the cross-sex hormones or the surgeries that remove the healthy body parts for based on their gender dysphoria or to transition, right? And so this law has been challenged by the federal government, and they are claiming that there's a 14th Amendment equal protection right to these procedures. And so there's a couple issues here. One, whether the Equal Protection Clause protects based on gender identity, transgender status, or the like. If the court says that it does, that's going to have massive implications across the board when it comes to things like access to sex-specific spaces or activities like sports, pronouns, and kind of the free speech implications for that, whether doctors are going to have to perform these medical interventions, including on children. And then I think also just like whether states can come in and say, no, we don't think children are able to provide informed consent to sterilize themselves, to remove healthy body parts, to subject themselves to a lifetime of medical care and complications from these interventions. That they need to wait until they're older and fully or be more likely to fully appreciate what they are doing. That a parent can't consent on a child's behalf to do that. And so I think that's the case that I'm probably most closely watching. That's going to have, if Tennessee loses, will have massive implications. If Tennessee doesn't lose, I think it won't have as many kind of far-reaching consequences other than taking those 14th Amendment equal protection arguments off of the table for folks that are trying to oppose various like these laws protecting the children or other regulations that don't that allow doctors not to perform these interventions or insurance not to pay for it and things like that. And so I think that's a major case that could have massive implications, or it might just kind of keep things more at the status quo.
I am curious, and this is my last question. As a person that looks at this space very closely, I'm referring to you, talking about religious liberty cases. Like, are there, like, do you find there are more religious liberty cases brought up in a Democratic or presidential administration versus a Republican? And I'm really interested because, like, I was thinking as you were talking, like, there's this idea that gun sales, for instance, like, tend to skyrocket during a Democratic administration because, like, there's a fear that they're going to come take all your guns. So, like, in a Democratic administration, do you find that there's more or less religious liberty type cases that are brought?
So I think, especially when you're looking at the current administration, they've been imposing abortion policies, gender ideology. They're trying to do a lot of this through the federal government. And at the same time, there's also been a decrease of respect for religious liberty, especially if you're a Christian, right? If you're not maybe a minority religion. And so in the healthcare space, right, there was a division of HHS, the Conscience and Religious Freedom Division, that got shut down. The employees who are experts in listening to these claims, they got reallocated to other issues. And so there's been kind of a systematic, we're promoting abortion, we're promoting like LGBT policies, but at the same time, we're minimizing the protections for conscience and religious liberty. And so when you have the juxtaposition between the two, there's, I think, going to be more space for those conflicts. Now, I mean, I would hope that a Democrat administration would be respectful of religious liberty and want to promote it, but that hasn't been the case under the current administration. There was some of these policies were being pushed under the Obama administration as well. And so the more the government's regulating, and I think Democrats tend to want to regulate more and more areas of life, Republicans, probably not to the extent I would like, but that they don't regulate as much, right? They still regulate, kind of the, like, what is the role of the government of stepping in? And the more the government's regulating, the more opportunities there are for those conflicts. And then I think the respect the two parties have for the place of religion is not equal, at least at the government level. And so right now, I believe that it's a pretty safe statement to say that under a Democrat administration, there's going to be more conflicts and more lawsuits. And when it is coming from the federal government imposing it, like the only recourse is litigation, right? And so if the government's not respecting your rights that they're supposed to respect, then you have to go to the courts to try to vindicate your rights.
That's awesome. Well, this has been super helpful for me, Rachel.
Yeah, it's great.
and really, really informative. And if people want to kind of follow the stuff that you're doing, your work, like where can they find you?
So eppc.org is our website. You can sign up for our newsletter. It'll share information about the work I'm doing on regulations and the other scholars who are working on theology type issues, technology issues, life and family issues, school policy, a whole range of things. And so we at EPPC try to apply Judeo-Christian values to law, policy, and culture. And so different folks are working on different areas. And my focus is the government regulations that affect human dignity. And I'm just so glad you guys are interested in it and brought me on and asked great questions to learn more.
Well, thank you so much. I mean, yeah, this is, like I said, really, really helpful. And we do try our best to present multiple sides to very, very, sensitive topics in the world of faith and religion. And your voice is very much appreciated. So thank you for coming on. Yes. To our listeners and viewers, hey, thanks for stopping by. And always make sure you keep your conversations not right or left, but up. And we will see you next time. Take care.